Hi, I'm Chris Soplensky from hr.blr.com. I'm here today with legal editor Joan Farrell to talk about retaliation. Understanding what it is, what types of actions are considered retaliatory, why these claims can be so dangerous for employers, and what employers can do to avoid them. Hi, Joan.
Hi, Chris.
My first question is, what is employee retaliation?
Well, basically, in the employment context, retaliation is any kind of adverse action that an employer might take against an employee who is engaged in protected activity. This would apply under federal fair employment laws like Title VII of the Civil Rights Act and the American with Disabilities Act. A classic example of retaliation is firing an employee because he filed a discrimination charge.
Thanks. What types of adverse actions constitute retaliation in the eyes of the courts?
There have been a number of court decisions over the past several years that expanded the scope of retaliation under federal fair employment laws. Several years ago, the Supreme Court ruled that retaliation includes any adverse action by an employer that would dissuade a reasonable worker from filing a discrimination charge. Not just an employment action like firing or demoting. In one case, an employer had filed false criminal charges against a former employee. That's retaliation even though it's outside the employment context. In another case, the court ruled that retaliation protection extends to an employee who reports discrimination during an internal investigation even though she didn't initiate the discrimination complaint. And more recently, the Supreme Court ruled that it's unlawful retaliation when an employer takes adverse action against a person because he has a close relationship with an employee who engaged in protected activity. In that case, an engaged couple both worked for the same employer, and the woman filed a discrimination charge against the employer, and her fiancé was subsequently fired. And he sued, claiming unlawful retaliation, and the court said yes, employees like a fiancé are within the zone of interest of those who should be protected from retaliation. So employers need to be aware of potential third-party retaliation claims.
And retaliation claims are on the rise. Why do you think this is so?
Yeah, they are on the rise. In fact, last year more retaliation claims were filed with the EEOC than any other kind of workplace discrimination claim. As far as why, one reason is court decisions that broaden the coverage of retaliation protection. Another is that employees often have more success with retaliation claims than other types of claims. What can be particularly frustrating for employers is that a retaliation claim can survive even when the underlying complaint of workplace discrimination is dismissed. That's because the laws against retaliation aren't tied to the substance of the discrimination claim. They're tied to the action the employee takes in filing the claim. As long as an employee has a reasonable, good faith belief that he's complaining about discriminatory conduct, that's protected activity. And there are different legal standards for proving retaliation. Generally, a person can establish a claim by showing that she engaged in protected activity, like filing a discrimination charge. She suffered an adverse employment action, like being demoted or fired or unlawfully harassed, and that there was a causal connection between the protected activity and the adverse action, meaning that the action was taken in response to the activity. Often, the timing of the action is used as evidence of that connection. For example, if an employee is fired a week after his employer finds out that he filed a discrimination charge, he can point to the timing of the firing as evidence of the causal connection. And generally, the more time that goes by between the protected activity and the adverse action, the weaker the evidence becomes.
So what can employers do to avoid retaliation claims?
Well, there are several things that employers can do. They're not new ideas, but they're still important. First, they should have a written policy prohibiting retaliation, and they should provide training to their supervisors and managers about what retaliation is and how to avoid it. Second, managers should know you don't fire employees when you're fired up.
Right.
Managers and supervisors need to understand that anger shouldn't ever dictate an employment decision. Once a person has filed a discrimination claim, emotions can run very high. Employers sometimes feel that an employee has been disloyal and respond in ways that can constitute retaliation. And on the employee side, any negative actions by the employer are going to be interpreted as possibly retaliatory. So managers need to do whatever it takes to cool down and stay cool. Part of their job is to act responsibly and professionally, even if they've been falsely accused. The third thing is to provide training and refreshers so that supervisors know what to do when they receive a complaint from an employee. A supervisor typically is the first person who receives a harassment or discrimination complaint, and his or her response is critical in resolving the problem. And fourth, employers need to apply their policies consistently. Selective enforcement leads to accusations of unfair treatment or retaliation. And if an employer does need to deviate from its policy, it should just document the legitimate, non-discriminatory reasons that it's doing that. And finally, the employer should post its policy against retaliation so that employees know how to go about reporting a complaint and what the procedure is for that. And finally, after an employee has complained, the employer should follow up. After an investigation is done, if one's done, the employer should follow up with the employee to make sure that there hasn't been any retaliation.
Right. Thank you. Thanks very much, Joan. For hr.blr.com, I'm Chris Soplensky, and we'll see you next time.